My approach to legal problem solving comes fundamentally from the way in which I see law as a system of rules. And like any system of rules, be the rules of a game, rules of a sport, it is a simplified model of reality. So what you do when you solve legal problems is try and find a way of fitting the messy, complicated, factually inconsistent nature of reality into these simple legal rules. And that means looking to find out what's relevant and what's not. And fundamentally, problem solving is about that sifting process of figuring out what's relevant. A really classic example of this is probably family law, which really, when it boils down to it, the two things that family law is really about is about the future welfare of children and the fair distribution of property. However, clients who come into a family law conflict, there's thousands of things that they think are relevant, that they're hurt by, that they want to tell everyone, that they want their opinion about what happened in Christmas 3 years ago and who said what to whose aunt. And part of the legal process in family law is to be able to sit down and say, well, there's only a narrow range of things that are relevant, and these are what they are. So most areas of law are like that. In order for the legal system to actually operate, we need to be able to cut things down into manageable portions. And sometimes it doesn't quite work, and that's a matter for law reform, where sometimes things that are very, very relevant are excluded. So where do you start? Well, a place to start is really, what are the features of the conflict? What is the fundamental conflict is about? Now, when you've studied law, you end up with a sense of, I guess, intuition about this. You don't necessarily remember everything you've studied, but you remember the principles, you remember the vague frameworks, and you remember a taxonomy. You remember how things really fit together. And that gives you your starting point. It gives you an idea of, this is something that's legally actionable. This is something that's about hurt feelings. And obviously people feel badly about hurt feelings, but that's not something that's part of the conflict that's relevant to law. And you focus in, I guess, on the nexus of the conflict. Is it about an object? Is it about use of a location? Or sharing of a location? Is it about a particular event that occurred? Is it about a particular interchange, physical or verbal, between people? So you look at where the nexus is that joins the factual conflict situation to the world of the legal rules, which are almost like sort of a layer of virtual reality that sit on top of our world. And then I would look to the relationships between the individuals involved in the conflict. Now, sometimes these are formal relationships that people have entered into. The marriage situation is one we can talk about, but contracts, employment. Others are contextual or defined by the law, be it common law or statute. So if you live next door to someone, there's a certain relationship about being neighbours. After I figured the nexus of the conflict, I would probably move on to try and map out those relationships and understand how those relationships work and how they're construed in law. Then I'd look to the law itself. And fortunately, with the advantage of a legal education and legal experience, I've got that vague map of taxonomies of how it all fits together. And some of it may be a bit blurry, but that at least tells me where to go. And then I start narrowing it down. Now, a good place to start is often a law textbook. They're kept reasonably up to date. You can't always rely on them in practice, but they give you the ballpark of where to start. You remember, this is something to do with the law of confidentiality. Bring up my old torts textbook, or I should bring up a new version of the torts textbook, and I'll find the place where it talks about confidentiality. And that provides the overview in which you can then drill down and focus, particularly on recent activities and what's relevant to your jurisdiction. Because remember, jurisdiction is very important. So I would use the legal encyclopedias, and I don't start with the legal encyclopedias because I find that they are a little confusing and they're not very good at setting up the big broad parameters. That's why I would start with the text. I'd then go to legal encyclopedias to make sure that the textbook's still accurate and that there aren't more details there that are relevant. But the best thing about legal encyclopedias is if there's an important case that was just decided a couple of weeks ago, and sometimes academics will set assignments on recent cases just to see if you've been able to check up on recent law, you'll be able to check up, what's happened and make sure that your knowledge is correct and up to date. And when you're checking the law, I guess there are a series of things you get. I mean, there are the legal rules, whether they come from precedents or from legislation, more often from legislation. There's the broad principles. We understand, well, this is the sorts of things the law are about. It's about fairness, or it's about justice. going back to that family law idea, we saw a fundamental shift from a blame-oriented form of family law, which was about what people had done in the past, to a new set of principles which are about looking forward and trying to solve conflicts in the future. So those principles often define our understanding of how the law operates and what we need to look for. Sometimes it's a case of going, okay, there's something more there I need to follow up on, because obviously this isn't the whole picture. And then when you find precedents, they're usually good for analogies and for arguments. So even if it's not a binding precedent that's directly on point, and that seldom happens, but you can say, well, these are the principles that inform that precedent, and that will help me say, by analogy, if in this circumstance, which is similar in these ways and different in these ways, that's what would happen. So then it's a case of sifting through the facts and trying to find out which of those facts are relevant and which are the important ones for those structures of law. And that may require, in the practical world, asking further questions. And a lot of what you do as a lawyer is to identify zones of ambiguity, because that's where lawyers operate. If the law is clear, you don't have much of a role as a lawyer. I mean, you just say to the person who's asking the question, this is the law and this is what you have to do. But where the work of lawyers is where the law is not quite clear. And you identify the zone of ambiguity and you find out, well, what are the alternative viewpoints? If this is ambiguous, it could be this or this or this. And this is the kind of argument I want to make. And this is the evidence that I want to focus on to substantiate that position. Now, there's a certain importance in the real world in choosing your fights. Because you might find a whole series of zones of ambiguity. And there's something known as the shotgun approach, where you just pick all of them and you try and pick all of them apart. Now, this doesn't tend to go down terribly well in practice, and it tends to waste a lot of people's time if you're making pedantic arguments on every single little point. Now, for the purpose of assessment, you might want to do this, but you also might want to think about choosing your fight in terms of the amount of effort and time you spend on exploring each of these. So if something is a really minor technical point, you might say, well, there is possibly a point here, but you're not going to really explore that. You're going to want to focus your argument on the points of ambiguity that are really, really meaty, and there's some substance in there, and there's an important argument. And don't waste your time in just trying to pick every single little piece. So that's my process. And I think the important thing at the end of the day is to make sure that you've gone through that process, you've sifted the facts, you've identified those areas of law that are relevant, you've made sure you haven't wasted time that are irrelevant, and that you support every point you make with both evidence and good solid argument.